Okay, so can we go ahead and get started? So welcome everyone. Welcome to the New Mexico Family Advocacy Program's 36th ECHO session. NMFAP is a model of respondent parent representation being implemented in the 13th and 2nd judicial districts that utilizes interdisciplinary teams of lawyers, social workers, and parent mentors working effectively together to provide quality representation and the advocacy and support families need for reunification or other preferred outcomes in the child welfare system. I'm Leslie Jones. I'm one of the lead attorneys for the NMFAP program. With us also today is our IT support. That's Jen Vieira. So if you have issues, trouble, with muting or unmuting or anything, Jen's the one that can help with that kind of stuff. We do ask if everybody could please mute and stay muted unless you're asking a question of our presenters. I also, let's see. So today's topic is Supplemental Security Income and Developmental Disabilities Waiver, Issues for Respondents. First, I want to thank the Corinne Wolf Center for sponsoring this session so that we can get CLE credit. You should have received, excuse me, the CLE form in your RSVP for the session if you're an attorney. So you should have that available to you there. If not, you can email us, NMFAP, and request that. Also, just a reminder that all the materials from this session will be on the website, which is part of nmcourts.gov, but the New Mexico Family Advocacy Program website in our resource library. So you'll be able to access all of the materials that are shared with you today. Also, so that we know who's with us, if you could please enter your name and email address in the chat. And when the session is over, we're going to please ask you to fill out a post-session survey, which is an integral part of our program's data collection efforts under a federal grant. The survey will only take a few minutes of your time. Jen will post the link in the chat box, and we thank you in advance for your feedback. Our presenters today are Peter Cubra and John Bishop. Peter Cubra is a lawyer whose practice is limited to representing people with disabilities. Beginning in 1984, he's brought several class action systems reform lawsuits against prisons, the state child welfare system, jails, training schools, and the state Medicaid agency. His work on the case of Jackson v. Fort Stanton Hospital and Training School resulted in the closure of New Mexico's state institutions for individuals with developmental disabilities and the placement of all the training school residents in integrated community settings. In 1986, Peter and Ella Joan Fenolio and Jeff Kaufman founded Advocacy, Inc., a nonprofit corporation whose lawyers represent abused and neglected children. He is a past president of the New Mexico Association of Counsel for Children, an affiliate of the National Association of Counsel for Children. Peter also served as a board member and president of the National Association for Rights Protection and Advocacy, an organization that
And Peter Cubra's computer is working at this time, unlike Leslie's, apparently.
Advocacy Services Disability Hearing Unit. He now represents. I'm sorry?
Go ahead.
Okay. So, so Jen, if you can pull up the PowerPoint, and we'll go through the learning objectives for today. So the learning objectives today, participants will have a basic understanding of the eligibility criteria for SSI, how to apply for SSI and disability benefits, and what evaluation is needed to prove eligibility, the eligibility criteria for developmental disability waiver services, how to apply for developmental disability waiver services, the services available through the DD waiver program, and the criteria for accelerating admission to the DD waiver program. Methods of protecting the rights of parents with disabilities when it is alleged that their disability prevents them from parenting their children, and methods of protecting the rights of children with disabilities when they are in state custody. So I will now turn it over to Peter and John. Thank you very much. We really appreciate you being here.
Unmute. So thanks, Leslie. Appreciate it a lot. I recognize here many esteemed colleagues and some people who've been doing this work for a long time. I'm semi-retired, actually. That description of me was a little bit outdated, I think. But I am pleased to be talking to you about these issues. John Bishop, Leslie, your voice broke up, and so your introduction of John, I did not hear. I don't know if others were able to or not, honestly. You want to your screen froze for a minute.
Can you hear me now?
Yes.
Okay. So John Bishop previously made Social Security and Supplemental Security Income disability decisions for the New Mexico Disability Determination Services Disability Hearing Unit. He now represents people seeking disability benefits.
And moreover, he's a longtime friend and colleague who I have turned to many times for help when I was representing people who need Social Security disability or Social Security supplemental income. And so John is going to be doing most of the presenting with respect to how does one get Social Security when you're working your way through the process. He is a master of trying to get through the bureaucracy of that. Jen, if you don't mind, do you want to put up the SSI eligibility PDF that we sent to you? And we're going to start with that. I want to say from the perspective of somebody who I have represented some thousands of people who receive SSI. And I would just say this one thing as an introduction and then have John take it from here, that for parents, there are two things that it's really imperative that an SSI eligibility determination will help them with. The first one is that they actually can get a cash allocation on a monthly basis. And John, let me know if what was on the SSA webpage is wrong. $783 per month is what they listed last week as the amount that a person gets to help with all of their needs. But the other thing that they didn't mention on the SSA webpage is that you actually get a Medicaid card. And in the case of the people who I've worked for, that's vastly more important than the cash, although the cash oftentimes is vital for people. And so it is my view of it, and I know that there are tactical decisions to be made about, do you as a lawyer for respondents want their disability known or not? And we'll turn to that later in the presentation, and I'll tell you why I think the answer is yes. But assuming that you don't have an overwhelming tactical reason in the lawsuit as the parent's lawyer to sort of conceal their disability, then I think that having a disability not only can help them with real life, but also can help them with their lawsuit for one reason. If you declare yourself to be a qualified individual with disability in a children's court case, and you can prove it's true and an SSI determination could be powerful evidence, then you are entitled from CYFD to a reasonable accommodation of your disability in your plan for reunification. And so we'll talk about that later. But for all those reasons, I think it is commonly and almost always in the interest of a respondent in children's court to be determined eligible for SSI. And now, John, do you want to take it from there?
Yes, well, thank you all. Peter, I think, was speaking generally when he said lawyer. I am a non-attorney representative, and I'm actually required to say that anytime somebody calls me a lawyer by the government. So non-attorney representative. I started working as a disability examiner. These are the people that participate in the decisions as to whether or not someone is disabled in the New Mexico Disability Determination Services in 1987 and worked there until 2001. And since then, I've been helping adults with disability decisions. I haven't done children's cases as an advocate. I want to start with just a reason for the way the culture is over at Social Security. Social Security disability was started in the 1950s. When that happened, the Congress set that up in the federal government, but the Congress members wanted to share the capital outlay funds or the pork with all the 50 states. And so that's why state of New Mexico employees are making the decisions at the initial application, the disability decisions, not the income eligibility decisions, at initial and reconsideration. And when that was set up, it was placed in the statute that 50% of all the allowed cases would be reviewed by the federal government, and 25% or less of the denied cases were reviewed by the federal government. And sometimes that's been as low as 2%. And I don't know what it is now. So when you have a case on a child or an adult that is so strong, you just can't believe they denied it. Well, this is an element of that. If a case is really close in their minds and the standards are really harsh, it's far safer for the examiner and the doctor to deny it, because it's less likely to get reviewed by the federal government. And that causes the circumstance that you've all seen, is that people get denied twice and then they go before the administrative law judge, which is the second appeal, and they're allowed at that level. So, but you can be denied. By the way, I'm going to refer to this document that's just been placed, but all of this stuff is stuff you can Google and you can figure out how to do the forms. A lot of you are probably doing it already. Unless you have questions specifically about that, I'd rather talk about the culture of the agency and how to persuade the decision makers to pay the claims. So you can be denied, or a child can be denied twice, and it looks like it's pretty much the same, and then it goes to the judge. But actually, the quality of the decisions, what's called in adults, the residual functional capacity, the most the individual can do, really matters. So it's important to advocate at the initial level and at the reconsideration level. And in adults, you're doing it by talking about their daily activities. You've probably all seen the forms, the adult function, or excuse me, I can't remember what it is, but basically it's the ADL form for adults. There's corresponding forms for the children, and I haven't dealt with them in 20 years, but I think it's probably the same. You really want to spend some time with those. And every time you list an activity, it asks you, the adult, about cleaning their house, doing laundry, doing mowing or that sort of thing. Those are work-like activities. So if you write in there, or if your client writes in there that they can clean their house and do their laundry, well, they're admitting to a job-like activity. So always add a limit at the end of that. Say, so if I do all these with my clients, so I interview them and they say they can clean their house. I ask them how long they can stand at the sink, or how long they can sweep or vacuum. Vacuuming is very tough for people with back injuries, which is very common. There's corresponding issues with childhood development. As I recall, there are 5, they consider whether or not someone meets a listing. This is all in the document that you all have. Then there's and you know, it's hard to meet a listing. If you have a diagnosis of Down syndrome, that meets a listing, or at least it used to. If the eyes are enucleated, in other words, there just are no eyes, functional eyes, that's going to meet a listing. You know, terminal cancer is going to meet a listing. But those, and there are a lot of those, and Social Security allows those early. But if it's a functional issue, somebody's got ADHD and they're not able to concentrate, or, you know, just a bunch of other things, oppositional defiant disorder, those cases are tough because there's listings, but it's very hard to meet. Then it goes to considerations of domains of function. So especially with the children, but really with everybody, list every possible thing that could limit them as an adult from working, or limit them as a child from participating in school or participating at home, or, you know, any intellectual functioning, because every allegation that you make, they have to investigate. So you get a much, even if you lose, you get a much fuller picture, or they get a much fuller picture, which you will have if you're taking this into a hearing before a judge. By the way, if the judge denies it, there's a step at the appeals council. That's the third administrative appeal. That one used to be, I would win about 50% of those. Now it's maybe 10%. They've really toughened that up, but you have to go through that to get into federal court. As a non-attorney, I haven't done federal court work. These folks, by the way, are all overworked, and they're in a culture that is a deficit culture. In other words, if you're doing well, that you don't hear from management. If you're struggling, you hear from management a lot. So it's tough culture to work in. And you know, one of my roles was as a union president for the disability examiners and steward and so forth. So you know, that I learned a lot about how they come down on people that are having trouble. So you might end up talking to people that are very bitter or burned out. They're good people, but they're in a really tough organization. Definitely, if you have statements from caseworkers, community support workers, care coordinators, definitely submit those. All of those kind of things build on your case, that especially with children, that there are significant limitations in the what they call the domains of or the areas of function. And you want to list every allegation, because you could have maybe 3 different areas where there's some limitation in their function. And with children especially, if you can prove some limitation in 3 or more areas, you can win. So you don't want to just say, well, this child's problem is depression. You want to list every possible thing that could limit their function. Then when you go into a hearing before a judge, if you've pushed what's called in adults the residual functional capacity, or its equivalent in children, down to that place where the disability examiner has denied it, kind of because if I allow this, I'm more likely to get, we used to call them bounces or edits. It's going to come back and tell us that we have to do it over, and then that counts against our performance appraisal. Then you have made it easier to get the judge to take the next step to disability. So really work these cases at the initial and the reconsideration levels. There's a program called SOAR, and I can't remember what the acronym is, where they teach this for adults. It's been mainly for people on SSI with schizophrenia or something that are hard to keep track of for a year and a half. So, and they have a similar program. Sorry, that was my timer. That went fast. They have a similar program for doing this, load it up at the initial level with lots of evidence. And then, a judge can say this person's disabled, but they only became disabled 6 months ago as opposed to a year and a half ago, So if you load that up at the initial level, you can get them more back benefits also. Wow, I'm out of time, but if you have questions, I don't know how you all want to handle that, Leslie and Peter. I could answer now or at the end, or you all can call me. My information is there. I am no longer taking disability clients. I always referred the children and people that speak Spanish, and sometimes there's an overlap, to an attorney in town named Michelle Baca. They're great at that sort of stuff. And definitely reach out to them if you want professional representation. Okay, I don't know if you can hear me. Back to you, Peter or Leslie.
I was assuming Peter was going to take over. Did you want to have questions now, or did you want to wait till later?
I am happy to answer questions. I know Peter has a presentation he wants to do on the DD waiver, and I don't want to tie up his time. Can you hear me?
Yeah, we can hear you. Peter, you need to unmute. Can you hear us, Peter? I'm not sure Peter can hear us. Peter, can you hear us?
So I cannot hear a thing at this juncture.
Oh, that's not good.
Oh, although somehow, Leslie, I just heard your voice, but John, I lost the last several minutes of your presentation.
Oh dear.
Although right this minute, my computer is operating. So sorry, John, and sorry, everyone. You want to catch me up where we're at, John, since I couldn't make you out?
John, Ms. Peter, I made a presentation both about the history of the program, my experience. I talked about the domains of functioning that are considered in disability for children. I referred people to your excellent document, which is called SSI Appeals Process, for the nuts and bolts of applying and so forth, but I can certainly answer questions about that. I gave people I urged people to provide a lot of information at the initial process, even though the culture of the organization is to deny claims at the initial level and the reconsideration level. You can get a denial, but still leave yourself in a much better position at the administrative law judge level. And then I was asking Leslie if she wanted for me to answer questions now or move on to your presentation, which I look forward to hearing.
Well, thanks. Appreciate everybody's patience about the technology. So the only thing that I am wanting to add before we get into the question and answer about the appeals process is this, that in my limited experience, a handful of cases where I was working on behalf of people who were eligible for SSI and who were running into the usual obstacles, was that I found that the zeal of the advocate was insignificant, speaking as a zealous advocate, but rather it was the technical knowledge. And so one of the things that seems to me imperative for us all to keep in mind as we're moving forward, whether it's on behalf of the parent or the child, is that if you can access a specialist, John, as I understand it, is not currently taking new clients as he's almost as old as me, I think. And so he is winding down his private practice. But there are other people, and John, at some point, I think it would be beneficial for you to mention anyone you know who has expertise in this area, because for us to fake it on behalf of the individual because we know something about children's court or even disability issues doesn't get us through the arcane details of Social Security administration process. And so I would say to all of us who've been burdened by having to go through law school, don't think you know what you're doing with a Social Security appeal just because you happen to know something else. Try and get a specialist or an expert. And John, I would appreciate it if you would explain the mechanism available so that people who don't have cash at hand can still get compensation to a professional Social Security advocate, because I think that's a critical fact. Do you want to do that now?
Yes, Peter, you weren't able to hear, but I recommended an attorney in town named Michelle Baca, whose staff and she are well practiced in childhood cases. They do childhood cases, and their staff are fluent in Spanish. So folks with needs for Spanish, either adult or parents of children who don't speak English, definitely go with her. You're absolutely right. It is an arcane process. The fee agreement, which is set up by the law, is that the representative, either non-attorney or attorney, non-attorney at the administrative levels, can charge up to $6,000 or 25% of the benefit, and that's a contingency fee. So they have to win the claim, and then, of course, if you consider that, it's 25% right at the moment of the decision. But if the child or the adult goes on to get that for years, it's way less than 25%. It's a bargain. If I had a child who was in this case situation, I would probably refer to an attorney because it's in a bargain, or a non-attorney specialist.
Thanks a lot, John. And so I will say this, that for both young people and parents, I want to make the pitch that getting SSI serves a lot of important purposes. And so it's like this. The individual, as I mentioned, who is an adult, has special rights, and there are two cases on point. If a parent is facing termination, the case of State XRL Children, Youth, and Families Department versus In re John D., that's 1997 New Mexico Court of Appeals 19. What it says is that the parent is entitled to a reasonable accommodation, but that the parent bears the burden of proof of demonstrating that they are in fact a qualified individual with disabilities. So for those of you who represent parents, you might think about it along these lines. What are the ways that you can establish, for all purposes, that this individual is a qualified individual with disabilities? Having the individual actually determined by the federal government to be eligible for SSI is very good evidence. And so I would suggest that that's a beneficial thing for you to be doing. Moreover, I think that whatever their specialness might be, whatever their disabling condition might be, it is advantageous for you to encourage that parent to participate in whatever kinds of treatment or therapy is available to them, and to actually follow through on that. Because it is, in some of the cases from other states that I have read, it is evidence that there is no particular reason to give them a reasonable accommodation if they don't endeavor to avail themselves of the service, right? If they are eligible for it, but then fail to take the treatment, then what's the point of keeping the kid in limbo if the parent's not going to change and become more capable of parenting? So you want to get that Medicaid card and you want the person to participate in all the services they can get. We know that CYFD is supposed to afford the person some services, but it is within their discretion, if they want to go to a counselor or a therapist or a doctor of their own choosing with their Medicaid card too. And so it is advantageous to get Medicaid so that you have some way to pay for services that may or may not be forthcoming through CYFD. And so I wanted to share those thoughts with you. There are more recent cases that I'll just say for those who have been to law school that are on point. And the most recent one is a Court of Appeals case from August 12th of 2020. And that is State XRL Children, Youth, and Families Department v. Hannah C. And that's at 2020 New Mexico, unpublished Lexus 255. And it's also number A-1- Court of Appeals -38341 for those who have access to that, which all of the lawyers, of course, do. And so I would encourage us all to make sure that whether it's the child we're working for, or whether it's the adult we're working for, that people who are eligible for SSI pursue it and then appeal in the likely event that they're not going to be granted it at the outset. And so kids who have some kind of marked and severe functional limitation with respect to some aspect of life, and that it is likely to last for at least 12 months or continuously, that makes them eligible. And so we want to see to it that the kids in state custody get that SSI determination as well as the adults. I can tell you, because I have not been working in children's court, except for one exception, for many years now, I am a novice in terms of what's going on in children's court right now in some ways. But the child on whose behalf I was trying to work in the last few years was a child who came into state custody with known and readily identifiable special needs. And yet CYFD never did anything to get the child determined to be SSI eligible. And so for those of us who are involved in these cases, whether you represent that child or the child's parent, it is incumbent on us to see to it that an SSI application gets done. Because as I understand it, there is in fact a policy that suggests that, but in practice, I could say from firsthand experience, in a one limited experience, CYFD didn't think of it, and CYFD didn't do it. And the child was in custody for years before we finally got the child's application for SSI done. Now, with that, I want to just open the floor for the questions about Social Security and SSI benefits of any sort that anybody has before we switch over to this different topic related, which is the Developmental Disabilities Waiver Services and Program. So who would like to ask some questions of John, or perhaps even me?
So I think that being a CYFD employee and that kind of thing, and as the child's PPW, would I want to make sure that I get that application filed like within the first few months of the child coming into care? Or would I want to have other recommendations in place, like from the therapist and those kind of things before I go doing the application?
Yeah, so at most, Social Security will pay back to the filing date on SSI claims. So every month you wait to file a SSI claim, you lose a month of benefits.
Thank you.
And as a practical matter, one can continue to develop evidence during the course of these applications. And so you do want to have something to point to as evidence that the child has some disability. And yet it could be as cursory to get the ball rolling as some regular pediatrician had said,
Yes.
wow, this child seems to be having a particular dilemma. You don't need to wait for a psycho assessment or a neurological or a specialist assessment. Anything that you could point to, and it could even be that the child, when they come into custody, I know they are supposed to routinely get some kind of medical and developmental assessment promptly. Whatever is the first document in hand is sufficient. John, would you say anything more or different about that?
No, that's correct. Absolutely correct.
So, Ms. Vigil, did that answer your question?
Yes, sir, very much so. Thank you.
Thank you. And let's see, there's a written question or two as well. I'm sorry, I'm not all that skillful. Sherry Truscott, hello. Your question, I don't know the answer to. The National Organization of Social Security Claimants Representatives, and there's a 1-800 number. John, are you familiar with that?
Yes, I am. I'm sorry about my phone. I can't turn the ringer off. Yes, that's one of the professional organizations for attorneys. It's long-standing professional association. There's another one called the National Association of Disability Representatives. I used to be a officer in that organization, and that's more the non-attorney representatives. However, there are a lot of attorneys joining that one as well.
Thank you.
Yeah, I'm sorry,
Sherry?
Peter, go ahead. I
Go
just
ahead,
had been
Sherry.
given that information by someone who had a child, and she helped the child through the Social Security process and had become a representative through that. And she gave me that information, and I've given it out to a few people, but I've never had anybody say, yeah, it's a real organization, it's a good one.
Yes.
So I'm glad to know that. And I'm really interested in Kristen Conley's question about the SSI benefits going to CYFD and versus, that really frustrates me that they would, take the SSI benefits from children who have them and not require other children to pay for their own care, or just because there is something coming in, they get it. I think that's wrong. It should go into a trust or something for them for when they're out. But I'd like to hear your opinions on that.
And I just want to say I have no expertise in that, since my background is in making the disability decisions.
And Sherry, I want to ask if there's someone who can help with Kristen's good question, because it was a prior millennium. The last time I was working for a child in CYFD custody who had an SSI check or had been deemed eligible for SSI. My dim recollection, though, is that with respect to an adolescent boy that somebody else on this call used to work for and as his therapist, and my recollection is that he in fact did end up with an amount of money in, I don't think they called it a trust, but it was a special needs account of some sort. Is there anybody on the line who's either with CYFD or the court system or a more skillful lawyer than me who can answer this one? Because I can't help beyond what I said.
This is Nan Erdman. I can answer that a little, but my answer is going to be incomplete and might have a few errors. But I did have a case where a private lawyer for grandmother asked for the child to be qualified for SSI. An application was filed, and he did get an accounting. What happens is CYFD takes the cost of their care that's attributable to SSI expenses and deducts that from the SSI amount. The SSI checks all go to CYFD. And if you're representing a child or a parent or or someone who's caring for these children, it's important toward the end of the case to ask for an accounting. If they spend the SSI funds appropriately, you need to check that. And if there are excess funds, you need to make sure that those excess funds are then returned to the child and his caregiver at the end of the CYFD case. Did that answer it, the question, Peter?
Man, that was great. Thanks so much. And it also tickled my memory banks. In the 90s, we tried to litigate this in some cases. And the individual on SSI, even if they're in some kind of institutional setting, and courts, I think, are deeming CYFD as an institutional placement, that there's a monthly allowance that is at the sole discretion of the individual, and it is unjustful enrichment for the provider of the residential service to keep that. And so there is a separate accounting system that CYFD was operating in the 1990s. And that, Nan refreshed my recollection about that, that you can ask for an accounting at any time in the course of your CYFD case if you're the child's advocate or lawyer. You can obtain those documents. And I did, back when Michael Martinez was a judge, get him to require an adjustment when they had failed to make available all of the funds that should have been provided for the individual, in my case, teenager, so that they ultimately, that was where they ultimately ended up with a check. Thank you, Nan. That was very helpful. What else on Social Security before we shift over to the developmental disabilities waiver issues that Mr. Trujillo asked a question about? Anything else on SSI? All right, well, let's just keep moving then. John Bishop, thank you so much for your expertise and for your contribution here today. I really appreciate it. So Jen, if you're able, the document that I'd like you to call up next onto the screen for people to take a look at is the one that's got the New Mexico Administrative Code in its title. Yeah, I think it was the last one in that list of documents that Leslie sent out to us. And while you're looking for that one, I want to just talk about what it is in the New Mexico Administrative Code that tells us when a person is eligible for the Developmental Disabilities Waiver Program. The person, this is at NMAC 8.290.400.1. And all of these materials, Leslie is going to, and Jen are going to post to the website so that you can draw them all down and have them all at hand as well. And what this says is that an individual is eligible for developmental disability services only if they have an intellectual disability or a related condition as determined by the Department of Health. And so the way that is playing out at this time is that there is no longer an entirely prescriptive list of special related conditions, but rather any condition that could be a related condition that is similar to an intellectual disability. So here's the controversy that keeps playing out. If a person has autism, but they don't have a low IQ score, can you get developmental disability waivers services? And so they changed this regulation in 2019, and it's no longer just a list of particular related conditions. It's any related condition, but it has to be similar to an intellectual disability as determined by Department of Health. So if the disability began before the person was 22, And if it results in substantial functional limitations of 3 or more things, then it's self-care, receptive and expressive language, learning, mobility, self-direction, capacity for independent living, or economic self-sufficiency. All of these materials you're going to be able to obtain so that you don't have to write all of that down. But that is what makes an individual, whether parent or child, eligible for the Developmental Disability Waivers Program. And so because there's a bona fide expert in developmental disabilities who I recognize who's on this call, Donna Niclario, do you want to take this opportunity to say anything about your practical experience recently of how the 2019 eligibility decisions are being made?
Sure. For particularly for people on the spectrum, it has been really, really difficult. And DDSD and the Department of Health has really fought. And I'm having, I'm having personal issues with one of my older kids. So you really have to stress the functional. So if you have someone on the spectrum who happens to have even 100 IQ, you have to stress how their functional life is impacted by their autism. If you don't have an ID diagnosis, intellectual disability, so you have to show that, because a lot of these individuals really do have great difficulty with just getting through. I have a 23-year-old daughter with autism and very high functioning, and but she can't get through her routine without a tremendous amount of support and prompting, and she did not qualify for the waiver because of what they perceive to be that she's just not disabled.
All right, well, thank you, Donna. Can people hear my voice now? Okay, so I'm just going to take it from there, Donna. I appreciate that feedback. Here is why every one of you who represents an individual, or every one of you who is a PPW or a social worker for an individual who has some form of intellectual or developmental disability, ought to try and get people onto the waiver. You can get services that are more elaborate and more expensive through the DD waiver than any other program I've ever seen in my 39 years of being a lawyer. I was a special ed teacher, and I worked at a group home for people with intellectual disabilities before law school. I have worked for literally thousands of people with intellectual disabilities, and the best services, most elaborate services, and most efficacious services I've ever seen anyone get comes through the DD waiver. I have clients in a class action lawsuit I'm still counsel in, where their annual budget for services is over $200,000. They live in a house. They have 24-hour care 7 days a week. They have 3 different kinds of therapies. They have special equipment, computers, and other high-tech equipment, and all of it is paid for through the Developmental Disabilities Waiver. It's a Medicaid-funded service, and so it is the best hope for getting minimally adequate services, and it is the only hope for being able to pay for elaborate, complex services. And once you're in the program, assuming the program stays afloat, you're eligible for that continuously. Did you get that? This is nothing like any other program that I have seen in my 39 years as a lawyer for people with disabilities. Now, because this DD waiver program is so rich for those people who get in the program and have an advocate making sure they get everything that they're eligible for, there is an access problem. This is a discretionary program. That is to say, states chose through a special application to the federal government to set up their DD waiver service program. And so you're allowed, unlike every other kind of Medicaid funded service, to limit how many people get into the service. So many of you know this already. I'm about to tell you there are almost as many people waiting for the service as there are in the service. So the DD waiver waiting list has become a curse word in the world that I work in, right? The DD waiver waiting list. It's akin to a black hole. The Department of Health webpage that I looked at a couple days ago said the average wait currently is 13.3 years from the day you file the application to the day you get the service. Huh? So every single one of us who works for any person who might need that service or benefit from that service should be applying for it as fast as possible. For children, there's sort of a logic that doesn't make any sense to me, but politicians seem to like it. If you're a kid and you have to wait 13 years, well, no big deal. The school system will take care of you. Well, come on. The school system offers you something, but it is nothing akin to DD waiver services. So every single one of us, for every single kid who comes into state custody and might be eligible, apply. Apply right now. And Jen, for some reason, your screen sharing has not appeared on my computer. Maybe it's about me and my ineptitude yet again. But if you can show it, there is a Medicaid waiver application form, which is in the materials that we sent you. Remember, everybody, you can pull this off of the webpage that is hosting this event and then download it into your computer if you can't see it right now. But you can just go to the Department of Health webpage and you can obtain that one-page application. It's pretty simple to complete. And anybody can apply on behalf of the person, whether it's an adult or a child. And so get that application in as fast as possible. And then, you know, the contest about how long will it take to persuade them you're right and that the person gets deemed eligible, right? As long as it takes less than 13 years to get the paperwork organized, you're still good because eligibility goes back to the day of your application, right? So apply early and supplement it and appeal and fight it out, okay? So if there's a message for everybody to get, jump right into doing the DD waiver application as fast as possible and attach to it what you have at hand. And that application, as with an SSI application, can get supplemented over and over again with more and better evidence, right? And so you don't need to wait for the perfect, but they have a list on the Department of Health webpage of what it is that they want from you. And so it's at nmhealth.org/DDSD/intake/ELIG, ELIG. All of this is going to be posted to the website that's hosting us. But there they have the list of things they particularly like. And so for children, an IEP is a very helpful thing. Any kind of psychological evaluation, any developmental evaluation, therapy notes for people who get, whether it's behavioral health counseling therapy or some kind of occupational or physical therapy notes, anything from a doctor, for whatever reason people seem to think of as persuasive because they've been to medical school. And so all of those things can be attached when you apply and then can be supplemented later if at the time of your application you don't have it. So with that said, I'm going to turn to Judge Starzinski's question. The reason that the thing is called a waiver is just archaic, but it goes like this. Back in the 1970s, you could only get Medicaid if you were institutionalized, right? And so you get the eligibility, that is, you could only get the kinds of services that will provide you a place to live and these elaborate therapies, in addition to medical, surgical Medicaid. If you wanted any of these specialized services, you had to be in an institution. That was the law from the inception of Medicaid until the 1980s, at which time they said, we're going to waive the institutional requirement. If a state wants to serve people with intellectual disabilities outside of an institution and it doesn't cost any more, we will waive the requirement of institutionalization. And so every state has a DD waiver. They all have designed them figuring out what they are willing to spend. And then they say, federal government, allow us to have a waiver for 1,000 people, or in New Mexico, I think we're at 4,900 people. And then the federal government says, okay, as long as you demonstrate it doesn't cost more to let people live in the community instead of an institution, then you can have the waiver for that. And so today,
Peter,
sorry.
can I jump in for a second real quick here?
Of
I
course.
just want to remind people that I know that there will be people who need to jump off because it's almost 1 o'clock. If you have other meetings or hearings, just want to remind you the session will go until 1:15. But if you do need to hop off now, I just want to remind you to please fill out the post-session survey, and the link was put in the chat. Thanks.
Thank you. I appreciate that.
Peter, the
Yes.
other thing that the waiver was called waiver, it did waive income eligibility for parents. So for their kid to get Medicaid, many parents did not meet the income eligibility, and therefore their kids could not, even though they were disabled, could not obtain Medicaid. And the waiver programs, whether they be the DD, MedFrag, all of those provided for waiving parent income for minor children.
Thank you, Don. Appreciate that. I'm trying to keep up with the chats here. If I wasn't a senior citizen, I'd be more skilled at it, I imagine. The long waiting list Karen Olson raises, and so here's what I would say about that. There are two developments that are being used in the short run. There's a thing called a community benefit. If a person meets the criteria for institutionalization and they are eligible for Medicaid in the ordinary course, then they can apply through the managed care organization with which they are affiliated for a thing called a community benefit. The community benefit has something akin to, I would approximate 67%, 2/3 of the services that you get through the developmental disabilities waiver. Your eligibility is just this much different in terms of you have to meet institutional level of care definition that's slightly different, because the DD waiver is based on the intermediate care facility for people with intellectual disabilities institutional care definition. If you meet that definition for like an institutional or group setting for people designed for people with intellectual disabilities, this used to be called intermediate care facility for the mentally retarded. Now it's called intermediate care facility for individuals with developmental disabilities. If you meet that criteria for a group home or ICF because of your intellectual disability, then you can get onto the DD waiver. If you meet the regular nursing home intermediate care institutional criteria, then you can get community benefit. So people who are eligible for a nursing home setting can get community benefit through the managed care organization, the regular Medicaid MCOs. Now, they hide that fact from you, and they make it hard for you to get the service, but it is true. And so virtually everybody on the waiting list is eligible for community benefit. As of last year, I was told there have only been 3 people from the wait list who had ever applied for community benefit who were told they didn't meet the other criteria for community benefit. You're only on the wait list if you meet the criteria for ICF-DD. So thing one, you can get community benefit through your managed care organization. And that's been the law for some time. And it's only recently that advocates have been pushing these managed care organizations and HSD to actually provide this statutorily available service. The second thing is that last July 1st, the Department of Health set up what they call a supports waiver. It is a mini little waiver package of services only for people on the wait list. And Michelle Lujan Grisham, former Department of Health Secretary and longtime advocate for people with developmental disabilities, rammed that through the legislature. So you can apply for the supports waiver to help both an adult, say respondent with an intellectual disability, or a child on the wait list to get the supports waiver services. Last I knew, they were saying the ceiling on those services is $20,000 a year. It's still significant services compared to nothing. And you do get a case manager. And that's a person who will help the individual navigate all the specialty services in the DD world. And so you want to apply for the supports waiver as well. The application.
Peter, and I don't want to monopolize, but I want to. The supports waiver, it's not a separate waiver to apply for. They're trying to pull people off the wait list and by date of application and are allocating as they go down the list. And taking the supports waiver does not mean that you cannot get an actual waiver slot when your magic number comes up, and it's 10,000. But the nice thing about supports waiver is that it also comes with a Medicaid card, which is a nice benefit. And the other thing is on the community benefit, the biggest problem is that the MCOs, care coordinators, don't know shit about how to get people allocated for the community benefit. They don't don't get me started. They don't even know that they have that benefit. So, and that's with all 3 of the MCOs. They are really slow to have their people trained and knowing what services they can offer their clients.
Thanks, Donna. You're not barging in because you have the up to the minute details that I do not. So thanks a lot.
Sure.
There is one other trick about if you're on the wait list, is there some way to get something? And before I go there, I'll just quickly say to Sherry Truscott's written question that the Me Via waiver is just a form of DD waiver, if you will. You can have what's called Me Via or My Way or My Path waiver, or you can have traditional waiver, but you got to get your place on the wait list to the top, and then you can elect whether to go with what they call self-directed waiver or traditional waiver, but you still are just stuck on that wait list. I am not at this time a fan of people choosing the Me Via waiver just because of the bureaucratic way that it doesn't really work very well for individuals who don't have a lot of ability to actually direct their own services. So a child or a person with severe intellectual problems, they don't probably have the ability to employ their own staff and manage a budget of $76,000 a year and buy their own services in a customized way. That's the idea of a self-directed waiver.
I thought that it was quicker to get on it, but you could be right that it's the same.
It is, in fact. You got to get to the top of the wait list, and then you can elect which path to take. I owe one last thing that is in the learning objectives that I haven't even mentioned, so I'll just do it now. One can make a gesture. If you're on the waiting list, you can ask for what's called an expedited allocation to jump to the top of the list if your situation is extreme. Back when I was a child in the 1980s, the expedited waiver application thing actually had meaning, and we were jumping people into services with some success. It in recent years has become such a tight funnel to ram through that people by and large are not getting this, but it is in their regulations. And so I will say that if you go to the New Mexico Health Department website, that's nmhealth.org/publication/view/policy/4173, you get to the 195 pages of standards for the DD waiver. I just gave you a citation. Now these are the pages, and here's what it says at page 16 of 285, that you get an expedited allocation if you meet one of these criteria, that the person's current situation meets the statutory definition of abuse, neglect, or exploitation. But that doesn't apply to the kids in CYFD custody if they're placed, right? Department of Health will say, per se, you're in state custody, your living arrangement doesn't subject you to abuse, neglect, or exploitation. Ipso facto, right? You're in state custody, we never let that happen to you if you're in our custody, right? So you'll be disqualified if the kid is in state physical custody. But if the kid is the subject of some kind of CYFD intervention living at home, that kid could conceptually, right, jump the wait list and get DD waiver services. Conceptually, it's a very small number of people who can get through this maze, but it's worth considering if you work for someone in that situation. For those of you trying to help parents, and the parent can't manage the kid because of the kid's specialness, and the kid's not in physical custody, then that would be a valid place, right, for you to help that parent apply for expedited DD waiver allocation. And then also, if the current available resources are inadequate to maintain or assure the health and safety of the person, on a couple of occasions over the years, I got kids in CYFD custody to get DD waiver allocation just because they needed a ventilator and they needed other things that were so extreme that a regular foster home couldn't do it, right? Or a behavioral need so extreme that even treatment foster care wouldn't do it. You might be able to get DD waiver, but those are real outlier cases. So I now think I have at least touched on our learning objectives. I also am going to look back to the chats to see if I've missed anything. But meanwhile, who wants to just audibly ask any questions of John or me, or Donna or Nan or anybody else on this call? Who else wants to ask a question in our remaining 5 minutes or so?
So Peter, I actually have a question that I wanted to ask about parents with disabilities that, at least in my experience, one of the huge frustrations with parents who have developmental disabilities or delays is that there aren't like group homes or anything where they can have their kids and have kind of support and that kind of stuff. The kinds of services that you're talking about, either through the community benefit or if by some miracle they actually, get on the, can get to the top of the list for the DD waiver. So if that's already been applied for them, would there be services that would be able to help them keep their kids at home? I mean, I'm just thinking that, we just assume that if a parent has a physical disability, that there should be services that can help them take care of their kids, right, to overcome the physical disability. But what about the developmental disability? Would there be services available to help the parent actually be able to parent the children at home? Does that make sense?
I follow it, and how I have to say that is that you've got to meet the either intermediate care facility DD or intermediate care regular nursing home level of care to be eligible for, in the first case, DD waiver, or the second case, community benefit. If the parent meets that, then for them to get those services, it can stabilize their living arrangement, get them some accommodation that might help them parent the child, yes. But you have to meet those level of criteria, as we talked about. And then there's the horrible waiting for the DD service. Best I could say.
But Leslie, there would be absolutely a way to pull together some piecemeal supports under the community benefit for a parent. And Peter, you and I are going to have a lunch and have a throwdown on MeVia, because MeVia is one of my most favorite waivers. And for if there's a parent who has their kiddo, has a kid, and the parent is the recipient of services, the MeVia waiver would absolutely drive better services, better supports, to have that child stay with the family, and for the parent to get the support that any DD waiver ever would.
So,
go ahead.
Donna, I'd love to get together. We don't have to throw down because I'd lose, but on MeVia waiver, I stand corrected. The way I said it was, if the individual can't manage a complicated budget and employing people and buying services and monthly paying checks and stuff like that, if the individual can't do that and the individual doesn't have someone else doing it for them who is totally trustworthy, that's when there's a concern. So Donna, I agree with you fully. I have friends who have their children on MeVia waiver, and the friends are very sophisticated, skillful people, and so that's the ideal waiver for their child. And I have friends who have intellectual disabilities who can do it, but it is for the people who don't have a sophisticated adult who is because there's a lot of bureaucracy in it, and they really have managed to make it a little trickier than it needs to be on MeVia. But I agree, Donna, MeVia waiver conceptually for people who've got somebody who's a sophisticated leader, it's a really excellent way to go.
Okay.
And Jim Starzinski, you have said now twice, DD waiver applications should be done, period. It's ideal to have a sophisticated advocate, but there's no way to pay for it. You can't get a percentage of a DD waiver budget and pay the lawyer, right? But there is an organization that does this work for free, Disability Rights New Mexico. It used to be called Protection and Advocacy System. They do have a limited number of advocates and lawyers who help with this. And so Disability Rights New Mexico, their phone number is 256-30-100. And you can turn to them for assistance. They will give you a paraprofessional and sometimes a lawyer to help, but they have a limited budget. But that would be a good way to go. And a professional advocate is ideal because, they're trying to keep the wait list down by saying people are ineligible. So sometimes you need a professional advocate, but you should start the process without one if you don't have one. And then you can wrestle it for years if you have to, and still get back to retroactive initial eligibility date.
So
That's
I'm gonna jump in. We are at 1:15. Time flies. There will be a PDF of the PowerPoint that will be in the materials for the session, and that will have contact information for both Mr. Cubra and Mr. Bishop, so that you can email or call them if you have additional questions. Just a reminder to please complete our post-session survey. It's very important for our program's data collection efforts. If Jen has put, I think, the link twice in the chat. But if you take a look in the chat for that link, to complete that. Our next NMFAP Echo Didactic session will be on March 16th, 2021, and the topic will be how to utilize a mental health expert in child welfare cases. Would also encourage all of our practitioners to let us know if there are any issues about which you would like us to have an echo training. And if you have not already done so, please complete the NMFAP ECHO survey that was emailed to our practitioners earlier this month. If you didn't receive a survey or have an idea you'd like to submit, please email us at echonmfap@gmail.com. And that's all I have. And I just want to thank you again, Peter and John. This has been really great information for us, important information for us, and we really appreciate your time.
All right, thank you.
Nice to see you all. Take care.